This afternoon we'll have a very engaging session. The session is, you'll see it on the program, is on the topic, when saving pennies costs millions. When saving pennies costs millions. The true cost of pathological arbitration clauses. And I must tell you that when I was asked to moderate this session, my first confession is I did not know what a pathological arbitration clause is. I knew what is pathological, but I did not know what are the arbitration clauses that are called pathological. And to help us to unravel this question, we have a great team of panelists. My own name is Charles Kanjama. I'm an advocate of the High Court of Kenya. And I'm joined on the stand by 4 distinguished panelists. I'll ask the first one to raise his hand when I mention his name, Daniel Nzeki. I'll be very brief with the introductions. Daniel Nzeki has a master's in law. He's a member of the Chartered Institute of Arbitrators. He's a certified professional mediator. He has several accolades as a young arbitrator, and he's from the firm of Majanja, Luceno and Company Advocates. He's a Kenyan, and he'll give us a Kenyan perspective. Then with us on the panel, we also have Syomiti Mwanza. Syomiti is bringing diversity, not just gender, which you can see already, but she's also in-house, because most of the other practitioners are from the other perspective. She's an in-house lawyer. She has a master's in law in international trade and investment. She's a certified legal auditor, and she has been in-house legal practice in the higher education space for about 10 years or more. And then we also have Dr. Chikwendu Madumere. Dr. Madumere has a Ph.D., and his Ph.D. was on the topic of ancestral model law. So if you want somebody who has looked at the ancestral model law from front, back, and sideways, is Dr. Madumere. He is also a member of the Board of Trustees of Chartered Institute of Arbitrators, or Arbitration, and is a member of the ICC Arbitration Commission. Dr. Madumere is from Nigeria, so he can also give us the West African perspective. And finally, I'm delighted also to mention a panelist, retired judge of the Supreme Court of Zambia, Justice Charles Kajimanga. Justice Kajimanga, apart from having the same name as I do, has a master's in law from Cornell University. He's a chartered arbitrator, a fellow of the Chartered Institute of Arbitrators, and is contributed to a number of publications on arbitration. So the topic is pathological arbitration clauses. And I'll first ask Daniel, in 3 minutes, to tell us, what are these things, this animal that you are calling pathological arbitration clauses? What are they? What does the comparative knowledge or learning on the topic tell us about pathological arbitration clauses?
When we talk about pathological clauses, what are we talking about? In very simple terms, I'm not going to bore you with the founder, or rather the person who coined this in 1974, but in very simple terms, a pathological clause is a clause that, due to its drafting, is so vague or ambiguous or contradictory that it may get to a point where it is not enforceable. When you talk about pathological clauses, or rather when we talk about the pathology, we are talking about pathology in 2 perspectives. Pathology is a mild or a cold, which is curable. For Kenyans, we like calling it homa. And is a terminal disease in a clause, which the only cure for it is, it's burial by judicial dismissal. And for that reason, then, the question that comes to my mind, and that one that we'll be seeking to derogate today, is it almost always that all pathological clauses in arbitration will always be subject to dismissal, or the courts and even the arbitral tribunals themselves can save these clauses by interpreting them in such a manner that they give intent to the intent that was put forth by the parties when they chose arbitration by using arbitration-related language. I think that's the main thing that we'll be seeking to talk about this afternoon, and hopefully when we leave here we'll have an answer. Thank you very much.
Most arbitration clauses are being drafted in contracts that involve commercial entities. Some of them use external counsel, some of them use the internal counsel in the contract formulation process. So we have the great benefit of listening to the insight of one of our internal counsel, in-house counsel, who will also give us some highlight into some of the kind of like jurisprudence from the courts on what are the kinds of clauses that have been deemed pathological and whether they could be rescued. Was the arbitration clause saved or the arbitration clause collapsed? Over to you, Madam Syomiti.
My role today, as senior counsel has said, is to give the perspective of an in-house counsel, a drafter, a legal practitioner, an arbitration practitioner, when arbitration agreement is put in front of you to draft, or an arbitration clause. And picture arbitration as a gate that disputants have to go through, and on the other side, there are so many benefits: cost effectiveness, expediency, confidentiality. And for them to go through this gate, they need a key. And you, as the drafter, you hold that key in your hand. And the key is an arbitration agreement or an arbitration clause. If you do a good job, if you draft a good agreement, if you draft a good clause, and you hand it over to the parties, then they're able to open that gate, go through to the other side, and get all these benefits that we have from arbitration. On the other hand, if we draft pathological clauses, we draft poor clauses where we mention arbitrators that unfortunately have passed on before we drafted the arbitration, we leave out the seat of arbitration, we do not mention the venue, or we mention non-existent appointing authorities, either by misstating the name or just stating an organization that does not exist to appoint an arbitrator, then the key that we hand over to the disputants becomes a key that is ineffective, cannot open the door, and then we give arbitration a bad name, which otherwise would have had so many benefits to these disputants. So seated here today, as we go on with this conversation, please picture yourself as a drafter holding a key. And if you came in with a good key, we hope that at the end of this conversation, we enhance that key and you open more doors to arbitration. And if you're holding a pathological clause, we hope that at the end of this discussion, then we'll be able to leave with a key that is effective. On the matter of jurisprudence, we will discuss it as we go through the plenary. For now, I'd like to hand it over to Senior Counsel. Thank you.
Dr. Madumere, who has a doctorate in ancestral, is meant to give us some nuances. You know, there's a general idea of pathology. You read the arbitration clause, and it's difficult to interpret. Even if you go to court, the judge or judicial officer has a challenge interpreting. But sometimes you might even have drafted the clause that looks okay, and still it ends up being pathological. So Dr. Madumere, please give us some of the nuances that can make an arbitration clause or agreement that appears on the surface to be okay, to actually be hiding inside it some of this pathology.
I think the first thing we must keep in mind is that arbitration, at the end of the day, is a justice system. It's a justice system chosen by parties to resolve commercial or investment disputes. Number two, question to ask is, what is the object of arbitration? Now, if you look at the model law, Article 1.1 of the model law, which is also reflected in the laws of most countries, clarifies that the object of arbitration is to resolve dispute in a way that is fair without undue delay and expense. The critical words there, undue delay and expense. Now, the clause in the contract is the cornerstone of the arbitration. Now, the essence of this conversation is to bring to our awareness that the clause sometimes is drafted in a way that defeats the object of arbitration. It makes, it triggers a lot of objections, triggers delay, triggers cost. And you could see that manifestation in a number of ways. I could just give us one or two examples here, and then later on expound on the point touched on by Daniel with regards to attitude of courts on how they respond to arbitration clauses. Now, this is a clause in Singapore. The matter was taken to the High Court in Singapore, and the clause selected an unknown or non-existent arbitration institution. They meant to say China International Economic and Trade Commission, China International Economic and Trade Arbitration Commission, CITEC, but they said China International Arbitration Center. Of course, that second one does not exist anywhere. And that became a subject of objection because the lawyer whose case is bad is looking for every straw that he can hold on to, either to confuse the tribunal or to destroy the work of the tribunal. So that is why it's important for drafters, in-house counsel, to ensure that it's drafted very well. Another case I want to cite is what happened in Nigeria, with regards to MCIArb Nigeria. They meant to say chairman of Nigeria branch of MCIArb. They wrote president of MCIArb. Okay. The only president we have is in London. The chairman, the one in Nigeria is a chairman. He went up to Supreme Court before it was resolved. Okay, and recently, just 2024, something again went up to Supreme Court with regards to the scope of the clause. Now, the clause says any dispute arising from or related to this contract shall be resolved by arbitration. Now, the claimant triggers the clause, and the respondent says, well, we are not indebted to you, therefore, there is no dispute. We own up to the fact that we are indebted to you, so therefore, the dispute is, does not exist, so there should not be arbitration. The question then is, can you have arbitration without a dispute? It went up to Supreme Court. You can imagine from the High Court to Court of Appeal takes about 3 years. From Court of Appeal to the Supreme Court takes about 3 years. So for 6 years, parties were interpreting a clause that was pathological. And then ultimately, the Supreme Court says, once there is no dispute, there can be arbitration. And that could have been solved if at the point of drafting, the draftsman had said any dispute, claim, or difference arising from or connected to. So I could trigger arbitration by reason of a claim or by reason of a difference. So there must not be a dispute. So these are kind of ramifications that you find in practice that you see that causes delay. And you can also see the importance of this in the rules of many institutions of arbitration. For instance, the ICC, I think it's Article 21 or 22, that talks about case management conferences and all of that. I'll leave it at that, moderator, and I will expand on it later.
Before I come to judge, I have a case that is currently going through the courts and in arbitration. And this case involves an arbitration clause that refers to the London Court of International Arbitration. And my client did not want to go to arbitration. And they filed a case in the High Court of Kenya. We were able to persuade the Kenyan High Court that this matter was not arbitrable. So we brought out a doctrine of arbitrability. And the other party went to London. Actually, they filed a case in the High Court in England, seeking an anti-suit injunction. I didn't know there was such an animal that existed until just the other day, that there are some courts that issue an anti-suit injunction, stopping you from proceeding in another country. I was perplexed. Anyway, to cut a long story short, in the course of the research, we found that there are times when the contract can be declared null and void, but the arbitration clause survives. So it's the arbitration which will determine whether the contract is null and void. But there are some cases where the arbitration clause collapses with the contract. And if you're able to demonstrate some fundamental problem with the contract itself, the arbitration clause falls with it. So this seems to be an aspect where there might be some pathology in arbitration clauses. And Judge, from your experience in Zambia, what have been the kind of cases where despite an arbitration clause, the courts in Zambia or other comparative countries in Africa that you're aware of have found the arbitration clause was not enforceable? In a few minutes.
So, why do parties enter into arbitration agreements? It's because they don't want litigation. It's because of the advantages that accrue from arbitration. They want finality. They want a system that is cost-effective and cheaper than litigation. And so they opt to go for arbitration. But there are times when their intention is not realized because of a failed arbitration agreement. And my sister there was talking about drafters. And here, lawyers play a key role in drafting these agreements. And I think that it's important for lawyers to carefully draft these agreements and not to recklessly draft them without due regard to the obvious disadvantages that will flow from a flawed or a failed arbitration agreement. I'll just give you 2 cases from Zambia which demonstrate the negative impact of pathological arbitration agreements. One case is Nyambe versus Toto Zambia. Now, in this case, the arbitration agreement was to the effect that if disputes arose during, and mark these words, during the continuance of the agreement, those disputes will be referred to arbitration during the continuance of the agreement. Okay? Now, the agreement meaning the underlying contract. This underlying contract was terminated, and the dispute arose. So this party went to court and commenced an action in the High Court. The other party applied to stay the proceedings because there was an arbitration agreement. The High Court judge, I would say, was also reckless in interrogating that arbitration agreement. He stayed the proceedings. So when the matter went on appeal to the Supreme Court, the court held that at the time that the dispute arose, the arbitration agreement had expired. You see, when you are reckless in drafting, and you and me know too well that disputes rarely arise when the contract is ongoing, because there's still love between the parties. Disputes often arise when the contract has been terminated, when the love is over. Okay? So this is a proper example of a pathological arbitration clause. I mean, the parties never wanted to go to court, but the Supreme Court said, well, this clause is unenforceable. It's inoperative, so litigation has to continue. There was another case, the Florida case. This one, in fact, came when I was in the High Court, so I had conduct of this matter. The arbitration clause say that if a dispute arose, it would be settled by, they put litigation and arbitration at the same time. So one party applied to stay the legal proceedings. So when I interrogated the arbitration clause, I couldn't stay the proceedings. Because as far as I was concerned, you can't have an arbitration agreement which talks about resolving a dispute both in court and in arbitration. So I declined to grant the application. I assume jurisdiction and determine the matter. So these are typical examples of pathological arbitration clauses. But again, counsel. You know, it's important that you take maximum care when you are drafting. This idea of cut and paste must be avoided.
I think many of us lately we've seen the dispute resolution clause includes different things. It says when there's a dispute, you can maybe go to court for interim relief. You start by negotiating for so many days. Then you go to mediation for so many days. Then you end up in arbitration. And sometimes you've actually touched on all the different methods of dispute resolution. In contract clauses, there's even an adjudication board that has been appointed. And this can introduce some issues. I think, Judge, you've made that very clear. Daniel, the ancestral model law recognizes a limited scope for intervention by the local courts. And many drafters want to indicate what is the limited role of the court in drafting. And at the same time, there is a question of how much role or scope should be given to the arbitral body or the appointing body to intervene when the dispute has begun. In your experience and based on the studies and research that you've done, what is the best approach for the person who's drafting the arbitration clause or agreement in regard to the appointing authority and also in regard to the role of the court? Should you be silent about it? Should you spell it out? What is your view on the matter?
The first thought that I have is every contract or every situation is different. And that's why at times we counsel, especially the young ones, on a Friday afternoon, you are tired. You call your colleague who you know, they have a template on a construction contract. You call them and you tell them, please share with me your template, and you just take it and paste it. Boilerplate clauses. There is need for counsel while drafting these agreements to take what I would call a conservative approach and provide each and every aspect that is needed for a proper clause. And while drafting this, they need to take in mind the different areas or spheres that they are operating in. Because, for example, a contract touching on an IP issue would ideally be very different from a contract that is touching on a construction matter. And when you put that into consideration, then at the end of the day, the one thing that you need to ask yourself is, number one, what is the scope of the disputes that we may refer to arbitration? Within which scope should this dispute be referred to arbitration, and which other dispute should not go to arbitration? Because number one, that would affect the issue of arbitrability, and that will define within which levels you should confine yourself. And number two, you should also ask yourself on the issue of finality. The intention of this contract, will it give finality to this arbitral award, or are we still setting aside room for the parties to appeal maybe on certain matters, specifically on issues of law? Because I feel that is one area that most counsel really miss out on. And that's why, for example, when you look at Section 39 of our Arbitration Act, is really, really underutilized in this country, because at the end of the day, many people will end up just going under Section 35 to set aside the arbitral award, but they are not thinking of Section 39 on appeal on points of law. And I think that should be very, very clear when you are drafting the contract. Thank you.
Okay, so the question is, when drafting the contract, it may be good to make reference to whether there is any scope for the court, and also what would be the role of the arbitral body. Is it just to appoint the arbitrator? Is there any other possible role? And this is something that I'll also want to hear from the other panelists. But let me move to Madam Syomiti. We've had in this week, they have called the arbitration clause the midnight clause, the one that is drafted last. My personal experience is when clients come to me to review contracts after they have a deal, those who don't bring the job to you early, and you review the contract and you flag out a problem with the dispute resolution clause. You tell them applicable law problem, arbitral tribunal or body problem. They tend to not think about the possibility of a dispute. We've heard that investors tend to have more bargaining power, those who are bringing in money, to insist on which is the applicable law, which is the dispute resolution forum. And sometimes the clauses end up being inherently imbalanced in terms of the interests of the local company or body that is entering into some investment or other kind of transaction with a foreign entity. The day the conflict arises, they then look for dispute resolution lawyers, and they start getting shocked when you tell them that the cost of this arbitration, even just the application, the appointment fees of the London Court of International Arbitration is so much, the arbitrator is charging such and such an hourly rate. So Syomiti, in your experience, how do you deal with this question of, you could call it difference in bargaining power, or sometimes called the battle of the forms, when you are trying to insist on a dispute resolution clause that is balanced between the interests of the parties, especially in international or transnational contracts?
When you're a drafter, take extreme caution with every clause. Most times we pay more attention to the clauses that create commercial interests, that have financial obligations, and then we just pass through the ones for dispute resolution. We start there. Ensure that you do not draft unconscionable clauses, especially where there's a imbalance of power. Always make sure that you cater to both parties to the dispute as best as you can, to avoid a situation where then we have to go back to courts to interpret some of these clauses. And some of them can be interpreted by the courts. Some of them render the arbitration process dead on arrival. So as a drafter, that is where we're laying the emphasis. Make sure that every clause that you draft, even when it's on Friday in the afternoon, take extreme caution. And Daniel has mentioned many a times, life happens. You have a deadline to meet, you are unwell, you had traveled, you come back, things have piled on your desk, there's a cocktail at 5, and these emails always come at a very random time, 4:27, come up with an arbitration agreement. Yeah? And what do? I call Daniel, I call Nigeria here, I ask, doctor, please give me a template. I take both because, of course, I don't want to be caught and mix and match and match and match. So at the end of it, when we review the arbitration agreement, when a dispute has now arose, we found that the language of the arbitration is French. I can only speak English and my native tongue. I don't know if Daktari here can speak French, so that he would be who we run to for assistance. So it's always good, be keen. Remember, you hold the key to arbitration for the parties. Make it easy for them. Make arbitration the only option for them. And the worst thing you can do as a drafter is to take away the intention of parties to arbitrate. And then you return them to the courts, and then you return them to interpretations that they were not subjecting themselves to in the first place. And as you've mentioned, when you're on the receiving end, if it's a donor that's giving you money, most times we tend to, just be very easy with it because we're getting money. But as a drafter, make sure that you protect the party that you're representing very well. Whether they're receiving the money or not, make sure that you protect their interests. And some of the things that we've discussed here are some of the aspects that will ensure that you come up with clauses that are very strong and very good, such as Daktari had mentioned before, the seat of arbitration, mention it, the appointing authority, be sure of the name, don't put an inexistent authority, and so.
But Dr. Madumere, to go back to you, you have experience in arbitration across the continent, and you even know what is happening in other jurisdictions, Hong Kong, England, and so on. Can you maybe share your experience for just 2 minutes or so of some of the situations you've encountered where there is a contestation about the arbitration clause or about the scope of the arbitration and how that has been resolved in different parts of the world?
For arbitration-friendly jurisdictions like the UK, Singapore, Hong Kong, France, and all of that, you couldn't rule out the possibility of having clauses that are pathological. But what you find in those jurisdictions is that the courts have developed to the point of looking beyond just mere mistakes to trying to pinpoint the intention of the parties. For instance, if you say if you made a mistake in naming the institution, but the court can still situate that intention to arbitrate, the court will still go ahead and uphold that intention. And outside of Africa, even within Africa, I could see the awareness is growing. For instance, in Nigeria, just like the chair was very proudly listing the achievements of the bench in Kenya. The same thing is happening also across other countries in Africa. For instance, in Nigeria, our courts have developed to the point of saying, look, in fact, even the CJ gave a directive, that once the intention to arbitrate can be situated in a given agreement, the court should ensure that they enforce that agreement. So in Nigeria, in Kenya, of course, that is not to say that you don't find instances where it's gone south, but on the dominant position of most jurisdictions in Africa is that the intention is respected. And the courts recognize that under the heat of work, in-house counsel can make mistakes, and they could just copy and paste without giving consideration to what they are copying and pasting. But courts will look beyond those, minor mistakes, unless it becomes very obvious, like the example given by, my lord, because one thing you must recognize is that the choice of arbitration precludes parties from resorting to other disposition mechanisms like litigation. So it has to be clear that you intended to arbitrate. So if the parties now say you either arbitrate or you litigate, that is neither here nor there. That is what they call non-exclusive clause. And most courts would say, I couldn't stay proceedings because of that kind of clause. And most courts will. And the decision given by my lord is what most judges would do. So the point I'm trying to communicate is that the predominant view of most jurisdictions, is that the courts will look at the intention of the parties in the clause. Reading the clause, am I able to, come to a conclusion that the parties intended to arbitrate? If the answer is yes, regardless of the pathology, courts will uphold that intention. But if reading through it, you cannot, establish that intention, of course, you would say there won't be any recourse to arbitration. You could go to courts and all of that. So generally, it's improving, and we'll get there. And to just add my answer to what my friend Daniel said with regards to what we should do, I think the general best practice, the starting point should be to look at the model clauses of institutions. Mm-hmm. Chartered Institute of Arbitrators has a model clause. NCIA has a model clause. ICC has a model clause. So work from those models and then tweak them to suit your preferences as agreed by the parties. Thank you very much.
Judge, a few years back in Kenya, I had a client who was an employee of a Swedish company. He worked in a number of jurisdictions. He worked in Kenya, he went to Malawi. Eventually, he was fired by his employer. and there was an arbitration clause in the contract saying that the arbitration would be done according to Swedish law. I don't know which body was to appoint the arbitrator. So we went to the Kenyan Employment Court, and we told the Kenyan Employment Court that, first of all, this Sweden is so far, our client cannot afford to go there. Just mitigate against this arbitration clause. And what I remember is that the court of its own initiative decided to ask the Chartered Institute of Arbitrators of Kenya branch, to appoint an arbitrator. So we did an arbitration in Kenya, which ended up very well for our client. And I knew there was an exception to the rule that where the parties have signed and they agree, they will apply it. But recently in Kenya, the employment court judge went even further. And he said that under the Kenyan employment law, arbitration is not contemplated. And that normally when you enter into an employment agreement, the employer has a higher bargaining power than the employee. And therefore, you can do mediation, you can do other things, but no arbitration for employment. And we know that ancestral model law talks about public policy as a possible basis for which you can set aside an arbitration award, which therefore, I guess, can also be extended to an arbitration clause. In your view, what are those situations, special situations, where arbitration, to have an arbitration clause, may be challenged by the court? Maybe it is a criminal law matter, maybe it is environmental law matter, and you have various environmental laws, or is arbitration something that can crawl and stretch to all areas of conceivable human difference? If there is a question of constitutional interpretation, like the case I was telling you the other day, where I was trying to argue before the English court, without having the right of audience, that this one requires Kenyan High Court to interpret Kenyan Constitution. And they asked me, but we can get an expert on Kenyan law to come to arbitration. That is not a reason for us not to proceed with arbitration. So can you tell us, from your experience, are there situations where the best intended arbitration clause, despite the expert draftsman, is likely to collapse? The context, what has been your experience?
Arbitration is consensual, and party autonomy is the hallmark of arbitration. But there are times when the bargaining power has an imbalance. And usually this happens when the other party is dictating the terms, and you are at a weaker point, but you need to sign that contract because you think you can benefit something from it. And this is common in employment contracts, where the employer just brings a tailor-made contract. You just have to sign. You haven't even negotiated any terms in that agreement, in that contract of employment. And so there are, in some jurisdictions, you find that there's law which protects such parties. I know that in our country, there was a recent decision, I think in the Court of Appeal, Judge Nicholas Shapiri was there, I'm sure she can remember it, where there was an arbitration clause in an employment contract. The employee was fired, or it was terminated, and she was not happy about that. So she proceeded to give a notice of arbitration, and an arbitrator was appointed. He rendered an award in favor of the employee. On appeal, the Court of Appeal set aside that award, Judge Piri, and on the ground that our Employment Act, under our Employment Act, it's not arbitrable. Okay, so in that sense, you could see that despite party autonomy of those two parties wanting to go to arbitration, the law comes in to intervene. Because of this lack of equal bargaining power in employment contracts, I think it's a question of really public policy that someone must be protected. Someone who is weak must be protected.
But before I come to you, I want to give Syomiti 1 minute because she promised us some authorities, some examples of decisions where arbitration clauses were pathological.
The Supreme Court of India was faced with a case where, at the time when the parties were coming up with the arbitration agreement, the person they intended to be an arbitrator was alive and well. Unfortunately, when conflict arose, the person had since passed on. And the court determined that the intention of the parties to arbitrate the matter was very clear, and they went on and appointed a former Supreme Court judge to act as an arbitrator. In another instance in Kenya, it was a construction-related matter where the parties provided that should any dispute arise, it shall be subjected to arbitration, and the appointing authority shall be the East African Institute of Architects. Unfortunately, that institution did not exist. Another instance is...
So what did the court decide?
That one you'll see me after the session and I'll tell you. That one I have to charge something for it.
Okay.
So those are pretty good cases. You add the ones from Nigeria and that's a good precedent.
Okay, very well. So, ladies and gentlemen, you've had the challenge of pathological arbitration clauses. For me, what I can add before I open the floor to the audience is that the question of arbitrability is now an important issue, not just in Kenya, but in the arbitration circles. And they're talking about both subjective and objective arbitrability, that there are some kind of disputes that may be deemed non-arbitrable, and the scope of arbitrability is varying from country to country. In the one case I remember I noticed that in Kenya, the scope is that you have made a substantial, not just superficial, but substantial claim of fraud. You can persuade a court that this matter is not arbitrable. But when we were in London, the London court had a different approach. Arbitration clause, arbitrator can deal with matters of fraud. What is the problem? Why can't the arbitrator deal with fraud? So the issues of arbitrability that are also coming in. And then there are the questions of if the contract is vitiated because of duress or undue influence, does the arbitration clause collapse with it? Especially if you can demonstrate that the arbitration clause is also one that is causing a lot of pain or duress or difficulty to one of the parties. For example, you need 3 arbitrators, all the arbitrators are charging a lot of money. So these are some of the, you could say, subtle issues. After you've done your basic drafting, you've got the clause from Chartered Institute of Arbitrators or London Court or International ICC, and then you have put it in the contract. These are some of the other cases that may arise. And so it's not an issue where you just need to be awake at 2 p.m. in the afternoon, and then you've sorted the issue of pathology. Pathology sometimes mutates. It may seem to be a healthy cell, and then it turns cancerous a few months or years later. So with that said, any comments or questions, any observations, anyone would like to say something? So there are 3 hands up on this side. We'll take 3. In the middle, are there anyone who would like to make a comment? And the middle side, on my left. Okay, so we'll start with there are 4. We start with Professor. Professor also taught me.
The more reason I got worried, Charles. Did I hear you as suggesting that where there is a clear worded arbitration provision, that there ought to be latitude to depart from it on the basis of some high-sounding moral or other claim. For example, a person who signs a contract with his eyes wide open saying, I will arbitrate any difference between me and my employer in Helsinki, Finland, what would be the option of a judge who is confronted by that? Rewrite the contract and say, why don't you consider Milimani? Or, and I think this is becoming a serious issue here in Kenya, where you have a pure commercial dispute and the court is invited to read into the contract some constitutional norm or other that varies the contract between the parties. I wanted to hear that from yours.
The panelists here.
Yes, and from
judge and from judge.
Yeah, because unfortunately I didn't hear that clearly.
There was also a hand up there. Calvin is also a former chair of the Chartered Institute of Arbitrators. As you make your comment, you'll give us some policy perspective.
Good afternoon, everyone. Thank you very much to the moderator and to the panelists. This is the 4:47 timing that we were told about. My comment is actually very close to what Professor has talked about. During my time as an arbitrator, I have had opportunity to handle employment disputes in arbitration. And maybe I've been lucky that their words have not subsequently been challenged in court. But to the best of my knowledge, if parties have agreed that they will resolve their employment disputes by way of arbitration, I don't think there is good reason to depart from that position. The point is this, I heard you to be saying that the reason for such departure is that there's an imbalance of power. First, is that true in the ordinary sense of any contractual engagement? And even if it were true, why would you assume that the court is better placed to balance the field as opposed to an arbitrator? Isn't it our experience that judges get it wrong, just like arbitrators would sometimes get it wrong? And therefore, what makes that forum superior or better or inescapable in terms of getting it wrong? I would be happy to hear the citation for that particular case so that many of us can also have a chance to look at it. And since the chair of the institute is present, it would be useful for her to look at it and see, is there room to do that policy position or communication that you talked about? But are we re-establishing public policy to say that employment matters are not subject to arbitration? That would be a worrying proposition in my view. And then there's an interesting case which has gone up the ladder and sometimes come down the ladder. I was going to talk about the case of Biatosha, where there's an ingenious argument about whether constitutional matters can be determined in arbitration and what the courts have said after that. But let me leave it at that. Then my final comment, and this goes to Daniel's point, he said, try to be as specific as possible as you do the arbitration clause. In my view, I would propose actually just include only a few important points and refer to the applicable seat of arbitration for the rest. To be over-specific, you risk now falling afoul of some of the pathological issues we've been talking about. Finally, is on the issue of fraud and whether an arbitral clause is still severable from the main agreement. My quick take, because of time, is the principle of severability has not distinguished that certain things are not severable as opposed to others. I would have explained further, but time is limited. Thank you.
Thank you. And because our manager of the afternoon session has stood up, is an indication that we need to move very fast. I'll also say that I currently have an arbitration. I'm the arbitrator between an employer and an employee in Kenya. And when it concluded, the employee was not able to pay my final arbitration fee. And actually, even the employer said, can you waive their final fee? And after some consultation, I said, no, they need to pay. And they have been unable to pay and collect their award. So these are just some of the challenges that sometimes employees or people who are less economically able face, even though there's an arbitration clause. I think Jacqueline will be able to tell the quotation of that employment case because it was quite, it spread quite a bit in Kenya. But one more comment, one last, because our manager of the session is up. One last question. Please be brief, just half a minute. Focus on the question or the comment, and then I'll get the last responses from the panel.
Thank you very much. So, as a drafter, I wanted to know, because we've been encouraged not to be verbose in our contracts, yeah? And I draft a lot of arbitration agreements myself, or clauses myself. So if it's in a full contract, can the relationship between the governance clause and the dispute resolution / arbitration clause be inferred on, I don't know if that makes sense, but can you infer from the governance clause, let's say, for example, that this dispute is subject to the Arbitration Act if your jurisdiction is the Republic of Kenya? Has my question made sense? Yes?
Okay, Syomiti will answer that question. Thank you very much. So we come to the panelists. I will start with Daniel. Are there areas like employment law, environmental law, maybe administrative law, where the courts might decide to ignore an arbitration clause? I think it's an open question. Daniel.
Thank you very much. Let me first start with the Chair Emerita's comment. When I meant specific, I also made reference to being conservative. And the level of specificity here is with regards to all the aspects that are requirement, be it the seat, be it the governing law and whatnot. And I think with that then it will complement your point that then we will avoid the pathology that comes with it. To my professor's question, who also happens to have been my teacher, on the issue of public policy, there's actually an article that has been published by Mohamed Muigai on public policy, and we talk about, since 1824, when this unruly horse was coined. It's 200 years down the line, but we've still never been able to, agree what public policy is. And they pose a very good question. Is it that the education system the world over has become so dilute that the only thing we are doing is promoting academic and intellectual laziness? And I think, Prof, when you are asking that question, it brings me to the case of the Canadian Supreme Court in the case of Uber versus Heller, when they were talking about unconscionable clauses. And that is something that has also been widely discussed in Kenya, recently, not very recently though, by Justice Mativo, as he was then, and the High Court. And they set the bar for unconscionable clauses to be very high. I actually agree with the dissenting opinion of the judges of the Supreme Court of Canada when they were analyzing why unconscionable clauses should not always be automatic, that, this case then should not be handled through arbitration. And I think from Prof's previous session, he was talking about having global standards that apply across all jurisdictions. So I think there's need for us to establish perhaps an internationally agreeable standard on what comprises public policy, because what is public policy in Kenya will be different from what is public policy in Zambia. Thank you.
To increase the situations in which you can sever the arbitration clause even if the rest of the contract collapses. Madam Syomiti, your final remarks.
With regards to the question that you have asked on whether you separate the two clauses, it's okay to separate the clauses as long as you do not create two distinct avenues for dispute resolution. Do not give courts exclusive jurisdiction, and at the same time, you subject all matters to arbitration, because then you'll bring issues in what to resort to. Then, when you mention the seat of arbitration, it's very different from the location of the arbitration. Simply mentioning the arbitration shall be in Nairobi is not setting that as the seat. So be sure to check for those small, small things that create a distinction. Yes. And in all that you do, remember, you hold the key for parties to go through arbitration and enjoy the benefits of arbitration.
Thank you so much. Dr. Madumere, there is a raging discussion about this question of party autonomy and pathological clauses, where people come later and despite party autonomy, they decide to go to court. What is your brief comment on that as you wind up?
Thank you very much. My closing remarks will be, number one, before answering your question, number one, to reinforce the point that the clause in a contract speaks to a dispute that might arise in the future. And that puts a lot of premium on the importance of getting it right. Because if you over-specify, like Mr. Kevin says, when this arises, you may not be able to meet those specifications. Now, to the question that you asked me, it's interesting actually to hear from the audience here that labor disputes are arbitrable in Kenya. And that is why it's important. That's the point made by Daniel is very important for us to look at different laws of different states. My understanding is that in Nigeria, labor law, because what we're talking about here is commercial arbitration, and labor dispute does not come within the definition of commercial arbitration. So my understanding is that the Kenya arbitration law deals with commercial arbitration. So it's difficult to understand how that law could apply to labor disputes. Because what we have in Nigeria is they call it Trade Dispute Act. That deals with labor disputes under a different framework, Nigeria Industrial Court. So the Industrial Court has an arbitration department that handles labor arbitration. Of course, the basis is public policy. So I understand that, but it's interesting actually to hear that labor disputes are arbitrable in Kenya. For us, what is not arbitrable is tax disputes. I mean, you couldn't arbitrate tax disputes, and you couldn't arbitrate matrimonial matters and criminal matters. So that is very important. And the point made by Prof also is very important, because I couldn't imagine a situation where, because the CJ of Zambia made that point this morning, that what courts are obliged to do is to implement the agreement of parties. So it's rare to see courts rewriting the agreement of parties. Even the example you gave, where the parties chose Helsinki, and you went to court and said they should now use Kenya, that court was very generous to you, I must say. Because in my office right now, we have a contract that specifies Greece as a seat. And the man has no money to go and arbitrate in Greece. And the whole thing ends at that point. Thank you very much.
Thank you. So we've discovered that in Nigeria there are some contracts that are not arbitrable, including employment. In fact, he's shocked that in Kenya we arbitrate some employment matters. He's mentioned marriage, he's mentioned tax, he's mentioned criminal law. We'll give the final comment to Judge Kachimanga to tell us, as you respond also to the question of Professor Githu Muigai, Attorney General Emeritus of Kenya, what is the situation in Nigeria, and in Zambia, and give your final remarks.
Well, Prof, if I were to give you my personal opinion, I would agree with you in total that if parties have entered into a contract with their eyes open, okay, they are bound by the terms of that contract. And when we bring it to arbitration, I talked about party autonomy. I mean, that's the hallmark. Parties with a clear conscience, have agreed that if a dispute arose, that dispute should go to arbitration, not to court. And I entirely agree that it's not the role of the court to start rewriting contracts for the parties. And I can tell you, Charles, I think you said you arbitrated unemployment. Is it Charles or Calvin?
Yes, both of us.
Yes. And I also want to tell you that I did the same. That was before the new Employment Act. And in my case, the employer was a big hotel. And the employee was just some junior staff in the hotel. So he was fired. Now, the contract of employment provided for settlement of disputes by arbitration. So I was appointed sole arbitrator. Now, fortunately for the poor employee, fortunately for him, the employer said they would pay my fees. So they paid my fees, and I arbitrated the dispute. But where the law says now employment is not arbitrable, what can you do? Until that law is amended or reversed, I mean, there's nothing you can do. You are bound by it. But my personal opinion is that, well, it doesn't matter whether someone there's an imbalance of power. As long as you've appended your signatures, agreeing to the terms of that contract, sure, you must be you must be bound by the terms of that contract.
So Judge Kajimanga has cast his vote for party autonomy. At this point, I would like to bring this session to an end. I would like to request all of us to give a very warm round of applause to the panelists for a fantastic job. And I hand back the